So this morning we are going to have an interactive session, and we have, as you will see, some of my INGOT colleagues that are joining us this morning. We have our Chief Executive, Martin Brassel. We have my colleague, Ian Goodyear. We have my colleague, Liam Swin. And I also have my colleague, Nick, who is also on the call. So what we will be doing shortly is breaking into two rooms. The easiest one will be the main room. You will stay where you are. And then everyone else, I believe, is going to join the breakout room, but we will talk about that with the conference technician in 1 second. But let's review what the plan for today is and to try and link our learnings from yesterday to today's session. So we are introducing a couple of SME case studies. These are fictional case studies, and we hope to use this as an opportunity for you all to ask questions of the SMEs. To be clear, those that are staying in the main room will be discussing a case study called Chocolate Heaven, and everyone else in the breakout room will discuss a case study called Fly by Night. So the key things that we want to try and do in this session is to treat it like an interview with a real SME. We would have some background information. This afternoon, we will talk about a typical process where before you have the interview, you will be able to pull together some basic information about the SME, and you would typically look at their website and do a little more research. So as you can see on my slide, we will be looking to identify the company's IP and intangible assets. Then to identify some obvious risks. Some may already be obvious by looking at a SME's website, and in this case, by reading the case study. So a good example from yesterday, our case study, in the information, we noticed that the company was using the registered trademark symbol, but we knew that they didn't have a registered trademark. This may happen in practice when you review a website and you find the same, and by checking your relevant IP registers, you realise no registered trademark is present. Once we have identified the assets and the risks, we will hopefully try and determine some key management actions for the SME. These can be very simple. We will not manage to do everything this morning, but we will try and pull out some of the key IP management actions. This could be as simple as registering a trademark. A reminder, the interview and the service that no doubt will be provided is not intended to offer legal advice. The interview is a very good time to talk through IP rights and IP issues with the SME. It is also not intended to provide commercialization advice. However, it is a very good idea to ask questions of the SME, to interview them and ask them about their business plan, and ensure you understand the aims of the business plan so that we can, as advisors, try and complement that with an IP management strategy. These should happen together. It is also not the chance to conduct formal IP searches or analysis. What you can do, of course, is conduct some simple IP searches, for example, a search of a trademark database. All of these will help to pull a report together, and we will talk through a template later today. And also that will then inform any post-interview activities. So what is the intention now is to break into two groups, as you will see. What we will start the session by doing is introduce the facilitators and the SMEs, the INGOT staff, to you in the room. We will summarise the case study, and I hope you have that case study. Apologies, it is only in English, but it is a very simple case study. It's intended to stimulate discussion. And then we can start to interview the SME. For technical reasons, if I can ask you to perhaps use the controls on Zoom to raise your hand so that we can start to ask and unmute delegates in the room to allow you to ask the questions. If I can ask someone to nominate themselves, one person, perhaps two people within each room, that would be really helpful to make some notes, and then we will come out of the room and present to everyone together some of the key takeaways from the session. So I hope you have managed to find someone in your room or in your group to do so. In terms of how I suggest that you do this, we want to try and identify the intellectual property and intangible assets. So you can think of what we did yesterday in the case study. It may make sense to start with individual IP rights. So you may wish to start with questions on patents, trying to pull out information on if there is anything patentable, then move on to trademarks and so on. And then pull out some more information on these wider intangible assets that we spoke about yesterday. So identifying the IP first, then at a minimum to pull out some risks, and from those risks we can determine some immediate IP management opportunities, and hopefully some activities from there we can discuss after. In the slides, there is also a table that has been provided by the EU IPO that is in the templates, which also sets out the IP rights and some risks that can be the subject of some questions.
First of all, I apologise for sun on my face here, which is a very sunny day here, so I'm sorry you can't see me very well. I'm Ian, colleague of Alison's, and I conduct with Alison most of the audits for INGOT. And I have with me here Liam, and I think I should also have Nick. So Liam is going to pretend to be the entrepreneur George in this case study, and hopefully you can all ask him lots of questions and find out what IP he has, what intangibles he has, what issues he may face in the future, where he might be doing anything illegal, and what opportunities he's got, what you'd recommend. So I don't know whether everyone's read the case study already. Maybe I should quickly review it anyway. So Liam, George, has established a company called Fly by Night. And it's basically a sort of mobile drone delivery service. So George came up with this idea while he was sitting in a traffic jam one day. And he thought that a fleet of solar-powered drones could deliver goods and businesses across all of Georgia, and reduce massively the number of lorries on your country's roads. So he did some calculations. I won't comment on whether I think they're realistic or not, but he did some calculations, and he thought that they could travel large distances and make lots of deliveries, even when the sun's not shining. He loved this name Fly by Night, because most of the deliveries would be done during the night. And so he put an R in a circle next to it, much like the Meter Geek person yesterday. He also registered a domain name that was free. So he thought he was free to use the name. He then set about designing his drones in detail. He did a lot of calculations. He enlisted a local engineering firm who produced detailed CAD drawings of his drone, worked out all the engineering required, and they created a prototype for him. They even created a streamlined design with distinctive fender features. I don't know if you know what go faster stripes are. That might be just an English term, but it's they basically made it look a really nice structured product. He then managed to get a grant and used this to fund a programmer to write some software code for him, and also allowed him to work with a local university who checked the feasibility, suggested some changes to the design and the technology, and finished the more technical parts of software coding. He thinks he solved a number of technical problems during this whole phase in very clever ways, and was very happy with the support the university had provided. So good news, he started to sell now. He's got a marketing agency involved who's produced some glossy flyers and leaflets for him, and a good looking website, and a YouTube channel. He's getting some videos made for him as well. And he's now in discussion with a major international supermarket who are interested in using his drones to move goods around from their warehouse. So it all seems to be going quite well. So he's come to the Georgian IPO looking for some advice and some support. At the moment, he's not filed any IP. He doesn't know much about IP at all. And really he needs our help. So assuming that's the case, how would you start an interview with him? I don't know if anybody wants to, whether it's best to raise hands when somebody wants to speak, or if somebody wants to just unmute themselves to speak.
I would have one question regarding solving the technical problems to identify how whether there is a subject matter for patent protection in place.
Yeah. Okay. So do you want to explore that with Liam? Because
drones are known, state of the art. So what was the contribution of the hired, was it engineer? No, what it was local university programmer. Okay, it was a software aspect. But anyway, it said some technical problems were solved in ingenious ways. So there might be some potential assets, intangible assets.
Yeah. So if we looking at the breakdown here of all the different sections we're going to look at, maybe we should start by looking at the patents, trademarks and designs, and then move on to the more intangible stuff. So let's explore for patents first. So, Liam, do you want to tell us a little bit about what you think might be patentable here?
Yeah, of course. So for the purpose of the case study, what could be patentable? I am assuming that calculations that I have drawn up are patentable in this regard. I am unclear if whether or not I can obtain a patent specifically for Georgia, or if it could be cast further afield. I don't know that. So I'm looking for advice really as to whether or not I can patent the algorithms and where I can obtain patent protection too.
And what kind of calculations were there? Is it about the design of the drone, or was it?
Yes, so the calculations in place were drawn up to facilitate faster movements of the drones without the need for sunlight between different places. The key selling point is the speed on what the drones can get to and from a location, and also the distinct look of the product as well. So I'm wondering if not only if the algorithm can be patented, but perhaps the actual look of the drone as well.
So as for patentability of algorithms, we in this regard, Georgian legislation follows the European approach, according to which algorithms belong to the list of subject matter which are not regarded as inventions per se, but the system, if we have a algorithm or soft linked to other components which have technical character in a system, so the whole system can be regarded as invention. So it depends what we see as an object,
whether it's a technical effect,
whether it has a technical effect. So there might be a potential for if we take the whole system in which we have technical features like drones, like server probably, or as a control center, and also the software which governs all the processes. So in the whole system can be seen as a patentable subject matter.
So I would, if I was doing this interview, I would probably suggest that it's possible that the algorithms may be patentable in this case, because there may be some technical effect here. But I'm not a specialist software patent attorney, and I'm not sure. So I would probably note down that there is a possibility that he could patent the algorithms, and that he should seek advice from a patent attorney and then make an introduction. Would that appear to be a sensible approach in this case?
Exactly. The term is computer implemented inventions, which can be a patentable subject matter. So the whole task here would be, for example, to be accomplished by a patent attorney to identify this computer implemented invention.
So our task isn't to say you can get a patent or you can't get a patent. I don't believe our task is to recommend that he speak to an attorney.
Okay. Exactly. And to explain to George that algorithms and computer programs taken per se, so without any other components, are not patentable subject matter.
And I think George was telling me he also had some inventions around an improved battery as well. University helped develop an improved battery that allowed it to travel longer. Is that correct, George?
That's correct, yes.
So from George, we would like to know all the technical contribution to the drones and to the system, because the technical contribution can be seen as the solutions can be potentially regarded as invention and protected by patents.
Yeah. So George asked about whether he could only get protection in Georgia or whether he could go further afield.
That's correct, yes.
Sorry, whether George can get protection in Georgia, is it the question?
Or only can he only get it in Georgia, or can he also get it across the European Union or the States? Or
first of all, we would advise to link it to the whole business model. So I mean, whether any commercial activities also intended or planned in other territories outside Georgia. And if it is the case, our recommendation would be to apply for patent protection in all those countries where the company wishes to have some commercial activity. But from the filing perspective, yes, George, first application can be filed in Georgia, patent application, after which subsequent application, for example, an international PCT application can be filed within 12 months after the first filing date. And from the PCT application, you can enter any territory, any jurisdiction you wish, including European countries via EPO, European Patent Office, in the regional phase in EP, and also other countries like US or Japan, depending on the business model you have developed for your commercial activity.
Yeah, so that is often the question asked in these audits. People aren't clear about the process. So obviously you are clear, Mirab, on the process, but the SMEs will often ask that. There's some concern I heard that he may have disclosed his inventions already. He started to sell this product, and maybe the algorithms are now in the public domain. So that might need a little bit of exploration as well.
Yes. So our question would be: have you already and in what extent you have already disclosed information related to the algorithm and all technical details? And because from the patenting perspective, all kinds of disclosures might be novelty destroying in the future for any future patent application. So currently we have in Georgia 12 months grace period for such disclosures, including self-disclosure. So if you have disclosed information somewhere, for example, on the internet, from that point, you still have 12 months grace period, within which you can file an application, and this disclosure wouldn't be novelty destroying for your own patent application. But this is not the case, so there is no grace period, for example, in Europe. So if you intend to get protection in European countries, you have to be aware that to avoid publications before filing an application.
So he may have a lot of time pressure to get an application in. If he started to sell it 9 months ago, he may only have 3 months to get his application in. And he may now only be able to get protection in Georgia because it would be considered disclosed in other territories.
Exactly. For any further contribution technical contribution which is not disclosed currently anywhere on the web, for example, you still have the possibility to file application for any jurisdiction, including PCT, EP, or US or Japan. So.
So would you also ask about ownership of these inventions? There's a lot of talk here about universities being involved.
Exactly, ownership is one of the important issues, taking into consideration the fact that some external persons were involved, including the student, the programmer, the student from the university. And do you have any agreements to those persons regarding ownership of a subsequent IP, for example, invention patent? Do you have any written agreement already?
Yes. So for the purpose of the case study, I would say that for the CAD drawings, I asked the help of someone who owned an engineering firm. No agreement is in place. For the programmer to assist with the software code and the algorithms, I haven't signed anything in place either. However, I do have a verbal agreement saying that I own the IP. The university who helped with the algorithms too, they made me sign something, but I don't know if that means the IP belongs to me or not. So I don't know what help you could offer.
This issue is important because the exclusive rights belong to the person, in the first place, to the person who has created the IP, including invention. So if there is no, what the risk could be if there is no agreement between the parties, and if one of the parties files for an application and the other party is not included on the list of applicants, there might be some conflict or might be some risk that the other party would apply for entitlement proceeding, for example, at court. So this issue should be clarified between the parties in a clear way to solve any potential problems in the future related to ownership.
Would you want to look at the contract with the university?
We would yes, exactly. We would ask to send us the contract in order to identify how these issues are regulated according to this contract.
And with a software programmer who gave verbal assurances.
Typically, also software is in Georgia subject matter of copyright protection. That's why we would. So sorry, you had also an agreement. Well, is it correct? Written agreement with the programmer, or was
verbal,
spoken yes,
agreement.
So in that case, and the verbal agreement was that George owns the IP. Is it correct?
That is correct. Yes.
But the code itself is written by the contractor.
Yes,
by the
correct.
Okay, there. I think this issue should be also clarified by signing a written agreement assignment, because there could be a possibility of there is still a risk if without any agreement there is a risk that the other party will change his mind and request or claim the ownership of the code for which this person was the author. So.
Yeah, the verbal agreement is hard. The problem with verbal agreements is hard to prove and demonstrate, so it's good to follow up in writing. Even an email confirmation may be better than what you have.
Exactly.
And what about the engineering firm? I guess it's possible to go back in retrospect and ask for assignment of any work that's been done.
And regarding engine design, distinctive vendor type structure. So
Yeah.
is there any contribution which could qualify as an industrial design? Or was it purely from technical needs, this type of design of the drones?
Yeah, it was for a technical need.
Okay, so if
yes.
technical, then probably there is no contribution to
designs.
design protection.
Yeah, it's important to clarify that, I think.
Yeah, because if a feature is purely from technical needs, technical character, then it would not qualify for protection as design, which relates the appearance of a product.
It sounds from a case study like some of the features were cosmetic, but George has clarified that they're technical. Okay, so we don't think there's any designs.
Okay.
The patents. Is there anything else? Anybody else on the call would ask about the patenting situation? Are any licenses required, for example? Are there any suspected infringements? Are they using anybody else's technology? These sort of questions maybe would come up.
Yes. Do we have to make a clearance search, the freedom to operate, to make sure that this technology would not infringe third parties' IP, third parties' patents?
I don't know the level of service that the Georgian IPO are offering. The freedom to operate search is a very in-depth, detailed, and expensive.
We are
to do.
So in reality, we are in the process of developing this service.
Okay.
And we are assisted by the Swiss IP office in this manner.
Okay.
But
what maybe you could suggest that then.
What we currently provide is a patentability search, a preliminary assessment of patentability, so novelty search. But in this case, the issue is about potential infringement of other parties' rights.
Yeah, you should identify it as a risk, perhaps.
Yeah.
Yeah. Anything else to mention about the patents or designs, or do you think we should move on to trademarks?
And maybe regarding the application, there was a graphical user interface could be also involved, which can be protected also as a design.
As a design.
And we can switch now to trademarks.
Okay.
And ask our colleagues from the room to.
Yeah. Any of your colleagues got any questions on brands or trademarks? Everyone else is very quiet. Okay, shall I ask a question?
Can you repeat the question?
Dear colleagues, do you have questions for George regarding trademark or design or any other issues?
Do we think he is definitely allowed to use fly-by-night, for example? That would be my first question.
So he needs to check it first of all. There is no information that he has bought this service.
Yeah, I would agree.
So we don't know yet, so we would rather ask him.
Yeah. I believe George thinks he's okay because he managed to register the domain name. Is that correct, George?
Yes, that is correct. I registered a domain name under the Georgian Domain Name Registration Office. I can't remember the exact name. However, I did register a domain name for fly-by-night. And so therefore, I believe I am entitled to have a trademark for fly-by-night. So I am unaware of how to actually apply for a trademark formally.
Okay, so as somebody said, I'm not sure who it was, you need to check the trademark registrations to confirm that it actually is free. Just having a domain isn't enough to give you the rights.
And how would I go about checking if I could register for a trademark?
Repeat the question because we don't hear very clearly. And if you repeat the question, it will be good. So we are seeing there is an echo here and we can't fix it. So please repeat the question, okay? Thank you.
Yeah, I think the question was how would George check whether he was allowed to use fly-by-night? Is it something that you would search for him, or you would point him to the correct website and give him instruction on how to check himself? Or would you recommend that he speak to an attorney to do it?
So first, let me start with the domain. Before we choose domain, it's better to check whether the trademark is available or not. For checking availability of a trademark, in Georgia, the company has chance to check it on our website or write to Patentability directly, and we will answer.
Okay.
Provide check on identical trademarks, and after that, it's better to get domain. So first trademarks and domain.
Yeah. Okay, so I think we've already discussed yesterday, we are in a circle problem, so we probably do not need to discuss again, but he needs to, we need some advice about removing that R in a circle until he has a trademark. What other things would you ask about trademarks if you were conducting an interview?
One question that I have about trademarks is I don't know how much it would cost to file a trademark or what goods and services I could use to best protect my company and brand. So I don't know the process of that at all. So that would be helpful.
So you need to learn about the classes and the costs depending on the number of classes required. Whether to apply for an EU-wide trademark or just one in Georgia. It appear to be different options.
We have two types of procedure. We have standard procedure and accelerated procedure. For one class, for example, for your services, what is such as delivery service, as I understood correctly, the cost will be 420, but we have a discount for electronic filing, 20%, and procedure takes for standard procedure takes 1 year approximately, but we have accelerated procedure as well, 10 business day the duration, and the amount of fee is double, 840, and again we have discount for electronic filing.
Could you also file one at the EU IPO and obtain protection in Georgia along with other EU member states?
We are not a member of the EU, so.
Oh, okay.
So yes.
Oh, okay.
Not yet.
Not yet. Yeah, but
Sorry, I didn't know.
But applicant can use Madrid system based
Okay,
on
yeah.
Georgian application. So
Mm-hmm.
we have
Okay.
this way.
Yeah, so you're part of the Madrid protocol too. Okay.
Yes, we are part of Madrid system.
Mm-hmm. Okay. So I maybe would also ask whether he has any other trademarks potentially, like does he have a logo at all? It doesn't mention it here, but I would want to explore whether he had any other trademarks as well. Again, I would ask about any infringements. Should we be looking to see whether anybody else is using something similar? Is fly-by-night a generic term? Would it be registerable, or is it considered descriptive, for example? So there are various things that could be explored here. Are there any more thoughts on the trademarks or the brands?
One question I would also have about trademarks is, would it be possible to trademark a slogan? I've seen big companies do it in the past, and I quite like the idea of trademarking a slogan in the future.
As a word trademark, fly-by-night, we think that it can be registered as a trademark for these services. It is not descriptive or generic terms, so it can be registered as a trademark. Mm-hmm. But the meaning is that these drones are not flying at night, so we think that it is distinctive trademark. It is not misleading or.
Okay.
And overall slogans can be registered in Georgia. So to answer your question, yeah.
Okay.
Mm.
Do you have another question regarding trademarks?
Not that I can think of. I don't know if there are any other questions for me regarding trademarks. I would like to register a logo eventually. I designed the logo myself, so I'm assuming that would be okay, but I'm not too sure.
So you can file the logo which was created by you. You are free, so you can apply.
Right. So, yeah, your service may be delivery services, which would be a service product, but maybe you also want to get protection for the hardware, for the drone. Maybe so you may need more than one class, perhaps.
So you have to choose 2 classes, and you have pay for additional class, additional fee for any additional classes.
So I'm not sure whether the Georgian IPO would help to advise here on what classes.
Yes, 39 is delivery services, and class 9 is for drones and other hardware.
Yeah.
And software, hardware are classified in class 9.
Class 9, yeah. Yeah. So I think this is probably important information for George to know. And quite often when doing this, we show them the TM class tool and allow them to try and find develop a description for goods and services using that tool.
You can find in Georgian in TM class as well. We have translation into Georgian and Georgian interface as well.
So I find that tool quite useful to show to SMEs at this point, so that they can see how the classification system works.
I would like to add one comment regarding software and the application. So our IP office offers the service of deposits to deposit copyrighted material. So you can use this service and deposit your code at our office. It's a safeguard. It doesn't the act of deposition is not linked to the copyright does not arise from this fact of deposition, but it's a good safeguard if there is any issue of ownership. So you can have you'll have the certificate of deposit where the time and the names will be registered, and you can use it in case of any disputes on ownership.
So we're moving on to the second category now, which is copyright, I guess. So you're correct. The main copyright asset is software, and proving ownership of that by depositing it in a registry would appear to be a prudent thing, given that this is probably one of the most important assets of a company. Yeah, George, I'm not sure whether you're aware that you could deposit your software.
No, I wasn't. No, all the code is stored online, which is accessible to myself and the engineering firm.
And we would like to clarify that this protection, the copyright for protection for the code for the app, is additionally to the potential protection of the system by patent, and the system might include in itself also the algorithm. And as I said before, algorithm or software taken per se does not qualify for patent protection, but code taken per se can be protected by copyright. So we can protect the code, the software per se by copyright, and possibly the whole system, which includes also algorithm, by patent.
So there's likely to be a discussion here about the extent of copyright protection, its use. What would it stop a competitor doing? Would it stop someone else creating another drone that flies by night efficiently? Or
exactly, if the copyright protection for your computer program, your code, would mean only the protection for the actual text of the code, but it would not protect from cases where another programmer would create a different code, which would possibly do something similar from the technical perspective. This should be taken into account. So it's a protection. The copyright protection is only for the concrete code, which and for the technical aspect, for the protection of technical aspect, is the patent. So if you file and get patent protection for the system, then you could use this patent to block the competitors using achieving the same technical effect by the same solution. That's why patent protection is more important for the technical, for the protection of technical aspects.
So there are limits to the utility of a copyright protection. Yeah, that's probably important to highlight and to bring out. So normally now I would explore what other copyright assets he may have that may have some value. So I don't know how you would progress. I would ask about whether he had any artistic works, any broadcast rights, any media recordings, which I see there's a YouTube channel. So I would ask about who created his multimedia content and whether he has contracts with them, whether he owns them himself, whether there are notebooks, digital or paper-based, that contain important sketches or drawings or calculations. Potentially there's quite a few copyright assets the company may have. There may be build manuals, process documentation, various copyright assets. You may also have some, we know that marketing agencies produce some marketing materials for him. Again, not sure whether he owns those, depending on the contract. There may be articles, press or scientific journal that are written. So I would probe all of these to find out what copyright assets he has, help him to identify them. He probably has quite a lot. So George, can you tell us some of the other copyright assets you think you have? I haven't heard that list.
Yes, I think I would have notebooks. These are both stored digitally and paper-based. I utilize artistic works. These were developed by the marketing company, and I do have an agreement stating that they belong to me. There's also quite a lot of use of databases. I don't know if these attract the protection of copyright. And there are lots of publications for what I do, both written by me and written by third parties. Again, I don't know if that warrants copyright protection or if that's an asset that the company holds.
When I looked on your website, I also saw some what looked like generic royalty-free photographs as well.
Yes,
Like
yes.
they came from Shutterstock or Getty or somebody.
Yeah, very true. In the early stages of website development, I utilized Shutterstock to get images to display on the website. I just plucked them from the database, put them on there.
So did you pay Shutterstock for those?
Not as far as I'm aware. It could have, I could have, I don't remember personally. I'm assuming I'd have to check an agreement.
So we can check.
So someone tried to speak.
You can double check if you have paid for the photographs, or if you have not paid for them, either you have to delete them or send the notification, or maybe it will be best choice to pay for the photographs if you want to use further on your website. So theoretically, you're infringing some copyright protected photographs. So it will be good advice if you will pay for it or if you will delete the photos from your website. Otherwise, in the future, when you will be using someone's copyright protected works, either you have to notify them that you are using them, or they will freely give it to you, or you will have to pay for it. Thank you.
Thank you. Yeah, that's good advice.
Yeah, thank you.
Your notebooks, do you keep them secure? Do you date them?
How would you define secure?
Are they encrypted? Are they on a dedicated server? Are they locked in a safe if they're paper-based?
The paper-based ones are locked in a safe. The online notebooks, they are on a server which can be accessed by myself and the engineering firm. This is in relation to the CAD drawings. In terms of encryptions, I'm not aware if these are properly secure or not.
Mm-hmm.
So with that in mind, how would I go about securing these notebooks properly?
I don't know if anybody has any comments.
So I understand those notebooks, the material in the notebooks could qualify as a trade secret. Is it correctly understanding?
It's possible.
Possibly, yeah. Yes. So the measures should be taken to make sure that this the persons who have access to this information are aware that it's a confidential information. It's on, and it qualifies as trade secret of the company.
They should probably have NDAs in place.
Exactly, non-disclosure agreements could be used among those persons accessing the information to make sure that this does not leak from the company. Mm-hmm. And to have legal instrument in case of any leakage or in case of any dispute.
So George also asked about databases. So I think his program uses a database that was designed. It also collects quite important data about how far the drone can fly in different weather conditions.
Yes, correct. There are lots of different simulations which can be found in the databases to see whether or not how the drones perform in certain times of the day, in certain weather conditions, etc.
So these databases are also confidential information. Is it correct? It's not accessible externally. So this qualifies as internal resource, which could be which should be kept secret. So it should be also protected as trade secret.
Mm-hmm. Okay. So is it possible for George to lodge pieces of his notebook or his trade secrets in the Georgian copyright registry as well?
Yes, database
structures and
Mariam or Irakli, would you like to comment on that? The database protection by depositing.
So any interested party, we have the same echo is disturbing us. Okay, now it's okay. Okay, you can come to Secretary and deposit your copyrighted database, and you can use it anytime. Or also, you can use it if you have lawsuit, or you have to prove that you created this database. So Secretary has a copyright deposit system. Just a fact approval, and you can use it anytime you will need it. And after depositing, you're getting a certificate, electronic certificate. And also you can file it electronically with your electronic platform. You don't need to come here. So it's very practical. Also, you can send it by email if you want with a supported letter, and it will be deposited in 10 working days.
Okay, so we need some kind of proof of ownership and proof of
yes,
creation.
It is just proof of creation. That's
yeah. Okay. Okay, so I wonder what other copyright he may have. Maybe some software. Sorry, some social media content. I don't know. Do you use LinkedIn or Twitter at all? Facebook?
Yes, I have LinkedIn and Twitter and YouTube as well. Although I don't know if YouTube is social media or not, but they are the 3 accounts that I use.
Mm-hmm. And you have a website?
Yes, I have a website which was developed by the marketing company.
Ah, okay. And do you have agreements with a marketing company about IP ownership?
Yes, I do. Yes. All of the artistic works created by the marketing company are owned by Fly By Night.
Okay.
Could you share this agreement with us for checking?
Yeah.
Okay.
Yeah, that is important to check, I think. So with all of these external contractors.
Yeah.
So if we move on to contracts, it appears that Fly By Night has a number of subcontractors: the software developer, the marketing agency, the engineering firm, and arguably the university as well. So where there are contracts, it would be good to check them. Where they're verbal, it would be good to ensure that they're turned into written agreements, and where there's no agreements, they should be, that should be rectified, or there should be some kind of IP assignment in place. So it's important probably to dig down when doing this IP assessment of exactly how contracts like that affect the rights of the IP for the company. Any other categories of contracts that you would want to explore as auditors?
For the purpose of this case study, towards the end of the case study, fly by night, or I have an agreement in principle or in waiting with a large supermarket to distribute the drones. I don't know what contract would be best suitable for this and how I would best protect my IP assets with this supermarket agreement. So some advice on that would be appreciated.
So with the supermarket, you have an agreement for using the drones and application.
Correct. Yes.
To move goods from their warehouse to their stores.
Yes.
Okay. And they will have access to the system as users to distribute their own goods to their own stores. So in that case, you are a service provider for this supermarket chain.
The product is distributed to customer from the stores, as I said, yes?
No, to the store, from the warehouse to the store. And also to the customers. Okay. Yeah, we should check this contract and make sure that the IP, there is no risk of any. There is no risk related to the IP owned by the company.
What other contracts would you be interested in looking at? Myself, I'd be interested in getting a list of the NDAs that have been signed, and maybe also identify where NDAs haven't been signed that maybe should have been.
Maybe we should go with licensing, but not exclusive licensing. I think so. But first of all, we should check the contract and we can think about it carefully.
Yeah.
But the good option will be licensing, I think so, and not exclusive licensing, because if we want theoretically to increase your business, you should cover other big supermarkets and other supply chains too, I think.
Yeah. Okay.
But if your IP will be protected and either you will have patent on your drones and other IP will be protected too, trademarks and copyrights, maybe we will go to trade secret. Best solution will be go to license agreement.
So what other agreements may, I'm conscious of time.
Maybe you go with franchise, but I think we can't.
Yeah, I think franchise is difficult here.
Yeah, franchise is difficult in this case.
Yeah. Yeah.
Well, I don't think that you want to sell your product maybe for the good price. Everything is possible. And everything depends on the amount of the money. Who knows? Yeah. And you should think about it. It's our opinion too.
Yeah. Okay. And what about the agreement between George and the company? Are there employment agreements or directors agreements? George, do you own? It sounds like this was your idea. I'm wondering whether you own the idea or whether it's your company that owns the IP here.
How would you define that? So are you saying that I need to have an agreement with the company? Some sort of service agreement or something? Or a contract?
What does everybody think? Does anybody have some comments?
I think we'll double check the facts. We will check the relationship status, and also we will check circulation of goods and so on, and then we can define what kind of contract will be more appropriate in your case. It will be service contract or license agreement. Maybe we'll have other suggestions.
It's probably important that it's clear whether a company owns the IP or whether George owns the IP. And if George owns the IP, he needs to grant rights to his company under a license. So this all needs probably to be clarified. Often with lone inventors, this is a problem I come across. And when George decides to file a patent or trademark, should he do it in a company name or should he do it in his own personal name and then license that to a company?
I think it depends on business model. So George, I think if you want to promote his company, it will be better if he should file for company's name.
Right. So I think these are important considerations when looking at the contracts. Are there any IP assignments that you have already, George? Do you have any? Has anybody assigned IP to you? I think you said that maybe the marketing company
Yes,
has.
just the marketing company has. There's also an agreement with the university, but I don't know the IP terms and conditions within that agreement.
Okay.
Yeah, that's the one we are supposed to check for details.
Yeah.
The agreement.
Yeah. And what if you find that the university owns most of the IP here? What would we do?
Well, in most cases, universities have their own IP policy, strictly defining the ownership issues, and in most cases, the owner of any IP created within the premises of the universities belong to the university. So. But there might be some topic related to any licensing condition.
Yeah.
But in case, according to the agreement, the IP stays with the university, we will have to check. We will have to check what licensing conditions are in place with the university.
It may be that George has to pay the university a license.
Exactly. That can be. There is a probability that this is the case, but we will check it anyway.
Yeah. Yeah. So it's quite a lot to check here.
Yep. That's what this pre-diagnostics is about.
Yeah, yeah, absolutely. Yeah. So the next section is resources, internal resources. So we've already talked perhaps about there being some trade secrets. So maybe we shouldn't discuss that anymore. But I wonder whether there's any other resources that we can pull out that George maybe isn't aware that he has or that's useful here. I'm thinking of things like a know-how, proprietary algorithms, proprietary data that might be useful for other purposes. Any trade dress or get up or sort of branding that isn't strictly a trademark. Unregistered designs and unregistered marks, all these kind of things.
I think we don't have here any traders.
No, not that we've seen. No. We have fly by night in a funny font at the top of the page.
Yeah.
But no, not really enough to qualify. Okay, so do you think he's likely to have know-how?
Any possible know-how could be incorporated in those calculations or notebooks which relate to the technical, which can be beyond the material which would potentially be included in a patent application.
Yeah, some of it also though maybe is not written down, not in notebooks, but in George's head.
Okay.
And then that doesn't have copyright protection. And there's a risk, I guess, that if something happened to George, that know-how will be lost to the company. So maybe we should be trying to work out whether any of this know-how is important, whether it should be documented, written down, turned into some kind of internal documentation. Might be something to explore.
Exactly, this material should be, everything which is not documented should be done so should be written down to have at least a proof of its existence.
Yeah.
If it would be included in the material of trade secrets.
Yeah, or even if not secret.
We would kindly also recommend George and advise to inventory IP assets, so it will be good for you to IP asset inventory, and then you can manage them and you know what you have.
That's a good idea.
What can you protect and what can.
Yeah. And you would help him. You would produce maybe a spreadsheet with headings so that he could.
Yeah, we can assist. Yes.
Yeah. Okay. A next category, quite important, is relationships. So I'm wondering whether he has any important relationships, whether he has a good idea of the market or has customer loyalty already. It doesn't seem to have customer loyalty or much of a brand or reputation at the moment, but he does seem to have some traction here with a large supermarket. Wouldn't say he has market leadership yet. Do you have many social media followers, for example?
No. How would you define lots of followers?
Well, compared to your competitors, I guess.
Yes, exactly. Not many then, no.
No. So in terms of relationships, quite weak on relationships. Got probably some quite good supplier relationships. Seem to have good relationships with the university and the programmer. And then the very last category is recommendations. So have you won any awards? Have you received any company accreditation, sort of quality standards, for example, or CE marks or equivalent? Have you received any grants? I guess could be seen as a sign of of endorsement. So I see you've already received some grants.
Yep.
If you're a member of any industry associations and you can advertise that on your website, that may be useful. So are there any sort of, I guess, recommendations or sort of endorsements?
Yeah, so as you've mentioned, there's a grant funding. I have connections in the industry with leaders on drone technology. So I believe that there are a few key relationships that I have.
Okay. Okay, everybody, we are that time flew by almost as fast as George's drone, and I'm being told that we have to leave a breakout room and have a discussion here in the main room. So thank you for your participation.
Thank you very much.
Yes, thank you for your interaction.
I think that was interesting.
This role play really has been a good start to introduce some of the typical questions that you may find yourself having to ask in a live interview with a SME in Georgia. Before I move on, do we have any questions from the main room or any of the breakout room delegates? I'm conscious we might have missed some of the key points. I probably have. Or if you have any questions before we move on. Anyone? I'm just checking my chat or any hands up. I'm hoping we've done our job then, Ian and Liam and Nick, and we have actually summarised what we wanted to, which is great. So let me just see. So yeah, so one of the things that we will move on to discuss this afternoon, I'll just keep my INGOT colleagues on the line for just 5-10 minutes longer, if that's okay. But typically in an interview, we would have longer. We would have longer to do the pre-interview research and also in the actual meeting interview. Now, what has to be determined in any service to be established by SAC Patenti is the exact nature of the service to be delivered. However, from our experience delivering a lot of audits, which, remember, possibly are a little bit broader than these IP pre-diagnostics, I would say on average, we would spend 2 to 3 hours with the company in an interview. You will understand that the initial period of time can be utilised well, perhaps 30 minutes for a company to introduce themselves, provide a company overview, a standard presentation, and that will help you as the interviewer or colleagues to understand a little bit more about the SME. What you will see on my screen, I think I'm still sharing okay, is a typical journey of an IP scan or a wider IP audit. And right at the beginning, the forms that you will send out to your client or to the SME hopefully will allow them to share some initial information on the types of IP rights they have registered. And hopefully they may actually identify some other IP that may be not registered. And also start to give a little bit of a feel of the commercial strategy of the company by way of a business plan. This may not be available. So on this basis, the secondary research is required. So the person from SAC Patenti will be wise to have a look at the company website and perhaps some news articles, some general website searching to understand a little bit more about the company. You will identify products and services that are on the market and in the public domain. And checking trademarks that could be subject to a very quick search of the trademark database. So in this case, we had a company called Fly By Night. If they didn't have any registered trademarks, a quick check before the interview is to see if this company name could be registered, if there's any prior rights out there. Then once you are in the interview, later today, we will talk through some of the templates that you have access to be able to collect the data that you require to allow you to then draft a report. And again, the report should have a standard format to ensure that at least basic information is collected and commented on. So the key IP rights in my chocolate cherry liqueur I was talking about yesterday. So the center part, the cherry, anything to do with patents, trademarks, designs, possibly plant variety rights. And then also to highlight and identify the liqueur part of that chocolate cherry liqueur, all of these wider intangible assets that we also discussed using the Gold Seam IP profiling tool. So as I say, that is a typical journey. This is something to be determined later this afternoon and going forward. And I've just put this slide up that I used yesterday as quite typical observations that we see from the audits that we conduct. And I think many of the companies that you will deal with, you will find the same things around the lack of coverage or registration of trademarks, checking if there is any patentable innovations within the business, checking the management and understanding of trade secrets, etc. So I think one of the things that we didn't have time to do today in the mock interview is to spend some time with the SME to explain what is a patent, what is a process. I think the other room perhaps managed to do that a little bit more, but we had so many questions. It's always good when you're speaking about an individual right to ensure the company is aware of those rights, how you can file for protection, what is possible under the law. So that really brings today to an end, or this session to an end. We have finished a little bit earlier than we planned, but it's just before the lunch break in Georgia. But this is the time to ask some questions. My colleague Ian, I think you have a commitment, so I might let you drop off. But before Ian goes, does anyone have any questions for Ian as the facilitator of the breakout room before he drops off, and my INGOT colleagues Liam and Nick? I'm hoping silence means that there's no.
I had one question, but if we are just quickly, if you're aware of WIPO IP diagnostics tool and how professional and how practical it is to use for this kind of uses with clients.
Yeah, that's something perhaps we could try and discuss after lunch, because I think I'm right that there's a consideration of translating this tool. It's not something we use as a team in practice. However, I have been looking at this tool, and it does seem to have a lot of useful information. I think the main thing is when it comes to the report, SMEs are very time limited. So they will get the most information and the most benefit from the interview itself. So one of the things that will need to be checked with the diagnostic tool is how the key recommendations can be summarized and condensed. Because from what I have seen, it does look quite wordy. There's lots of words, lots of information, but it is a good opportunity for the SME to do further reading. This afternoon, I will explain some of the things that we do and some of the things that is recommended in the EU IPO IP scan service in terms of attaching an appendix with more information on the individual rights. And I think that is something that the WIPO diagnostic tool could be helpful for, but we can probably discuss that this afternoon, if that's okay.
Okay, thank you.
Thank you.